Welcome back, everybody. So today we're talking to DeDe Soto again about real estate and estate planning, how to transfer property in Newport Beach. And on a recent episode, we talked a little bit about the basics of that and some strategies you can use for property transfer. We covered some topics like trusts and title and tax considerations when you're transferring property. And today we're going to get more into some special scenarios, talking about how to handle family dynamics and then complicating factors like out of state or multi generational ownership. DeDe, welcome back. How are you today?
Great. How are you?
I'm
Thank
good.
you.
Good. So let's dive right in. Let's
Okay.
talk a little bit about family. What advice do you have for retirees who maybe want to pass on vacation homes or income property in Newport Beach to their kids?
That is a great topic, and we get that asked a lot. People have second homes or third homes, or maybe their primary home that wants to become a rental property as well. And you can do that. There's, various different tools, a revocable trust that is, generational. You can pass it on through revocable trust, through some irrevocable trust. You have to be careful with some of the tax consequences. And then, of course, LLCs, which are limited liability companies, is a great way, especially if you have multiple family members that may want to enjoy the property on a annual basis, monthly basis, or share it as well. So there's a multitude of different tools that you can use that really work best, but also it has to do with, the family dynamics. Is it one child, two, three, four? How many different people are going to be using the property? And then you have to take a look at, are you trying to transfer it while you're alive, or do you want to transfer it, upon your passing? And then sometimes people will say, well, I want a home for my son or daughter to move into, right? So then that's another consideration that we can take a look at and create that entity to assist in that transfer.
So, how do you handle a real estate transfer in California when the original owner is no longer mentally competent or has passed away, like without a trust?
Well, those are kind of two different scenarios. So I'll take the one where they're incapacitated,
Hmm.
right? So depending on how they pre-planned, right? Did they have preventive medicine where they actually had a trust?
Hmm.
If they had a trust and their son, daughter, a professional is serving as the trustee, then the trustee has the capacity to go ahead and sell, right?
Hmm.
So they can sell the asset for the benefit of the beneficiary who's incapacitated. Now, you're looking at a different situation where mom or dad, brother, sister, whomever it is mentally incapacitated, right? They have cognitive issues going on. And then the question is there a conservatorship or is there a trust? So I'm going to sort of take a look at the fact that it's a conservatorship. So if it's a conservatorship, believe it or not, yes, you can sell the property if they're no longer living in it. Maybe they've had to move into a care facility and they need the money for their care, right? So someone needs to sell that. Well, you actually have to go to court and get approval to sell mom or dad's house, right? So it is a process where you have to give public notice. And then, there's a public sale, there's a private sale. So it depends on the situation as to how that conservatorship asset would be sold.
Okay.
Now, if there's an asset that is titled and somebody passes, then now we're in probate court, right? I always say probate should really be a four-letter word, right? Um, because especially if you're alive and a family member is having to go through probate.
Hmm.
And they're having to go through probate because you're alive because you did not have any trust or durable power of attorney, right? And so you're having to get authority to be the conservator over the conservatee. And but you're dealing with the probate court, right? And the probate court is backlogged, just going to say, right? So and this process of selling the property, right? It's that conservatee's asset, but they forgot to plan, right? Or and now someone has to step in and you have to go through the probate process um to in order to sell the house. But if it's in a trust, then you can avoid that. And so that's why I'm a big proponent of, plan while you're alive and of sound mind. Don't procrastinate. Because so many things could happen, right?
What are some of the most frequently asked questions you get about how to do this, how to transfer property in California?
Some of the questions, well, a lot of times people will say, "Well, can I just add my son or daughter to
Mhm.
title?" Right? And I know we talked a little bit about this before, but when you're adding your son or daughter to title or your niece or your nephew or whomever you're adding to title, you might avoid probate, but what happens is you're not that person who's on title is not going to get a step up in basis
Mm,
when the older person dies, right?
mhm.
So then now you have a capital gain issue if you go to sell it because the basis of that property is when the other joint tenant had purchased it, right? Or then you run into the issue of, let's say you added someone to title and now the older person, right, whether it's mom, dad, brother, sister, it doesn't matter, they need that money, right? They
Mhm.
need the equity that is in the house in order to care for them at their care facility or, at their memory loss facility. But now all of a sudden, someone else doesn't want to sell, right? They want the property because guess what? When that older person dies, they get it if it was joint tenants by right of survivorship. So, then there's some shenanigans going on, right? So I always say, keep your property, your assets, under your umbrella. Why bring in other parties? Even even to the extent of I know we're talking about real estate, but when you have your trust in your will, um, and your durable power of attorney, right? I'm not of the belief that you should pass it out to other people, right? You want to keep it, let them know where it is, but you don't need to have multiple copies out there. And so kind of going back to that question, some people can sell real property with a power of attorney,
Mhm.
right? So if they have that statutory power of attorney or general durable power of attorney, they can actually sell the property if someone becomes incapacitated.
Okay.
So it's yeah, you really want to do the planning as opposed to having a conservatorship. Um, and you do the planning with the trust and the will, those 5 essential documents that we have discussed.